Hi, this is your instructor, Suzanne Bichard. This past week in tort law class, we learned a lot about tort remedies. We discussed the three main categories of tort remedies, which are compensatory damages, punitive damages, and nominal damages. As we learned, compensatory damages are those damages that are intended to compensate the plaintiff for his or her actual losses. Punitive damages exist to punish the tortfeasor for egregious conduct and to deter others from engaging in similar conduct. And nominal damages are small token awards. These are given when the judge or jury determines that the defendant has technically committed the tort, but that the plaintiff didn't suffer any actual harm as a result. In this lecture, I want to focus on compensatory damages because compensatory damages are the most common form of monetary award in any successful lawsuit. Why are compensatory damages the most common form of award? Well, it's because most tort lawsuits are based on ordinary negligence, such as automobile accidents and that sort of thing. Punitive damages are awarded only when the defendant's behavior is willful, intentional, malicious, or outrageous in some way. Ordinary negligence, such as causing an automobile accident by failing to yield the right-of-way, is not the type of egregious behavior that lends itself to punishment in the form of punitive damages. And nominal damages are really not available in negligence cases because an element of every negligence claim is damage to the plaintiff. Because compensatory damages are the most common form of monetary award in any tort case, it's very important for a paralegal to understand what goes into determining the client's compensatory damages. Compensatory damages include both economic losses and non-economic losses. Economic losses are those things that the plaintiff has had to pay for or will have to pay for in the future as a result of the defendant's negligence. Economic losses can include such things as medical expenses, lost wages, the cost of repair or replacement of property. Those losses are often comparatively easy to quantify. So the paralegal will want to keep careful records of all potential losses as early in the litigation as possible. Non-economic losses are often referred to as pain and suffering damages. These are personal to the plaintiff and are usually more difficult to quantify than economic damages are. Pain and suffering damages involve compensating the plaintiff for such things as grief, mental anguish, humiliation, embarrassment, depression, that sort of thing. As you can imagine, it's often very difficult to assign a dollar amount to someone's pain and suffering. Because they are difficult to quantify, pain and suffering damages tend to be a bit controversial. For instance, some people are afraid that juries might be motivated to award outrageous sums of money simply because of sympathy for the plaintiff, or because of a misplaced and inappropriate attempt to punish the defendant. As a result, some states have passed legislation that places an upper limit or a cap on the amount a plaintiff may be awarded for pain and suffering in certain types of cases, such as medical malpractice cases. As a practicing paralegal, you'll want to stay informed about all developments in the law of damages in your jurisdiction.